Hello everyone, my name is Radu Ștefan PăNTRU. I'm a lecturer PhD at the Bucharest University of Economic Studies, and I will present the paper called The Legal Regime of Internship in Romania in terms of the regulation contained in law number 176 on 2018 of the internship which subsequent completions and its relevance for business environment. The beginning of a career is a very important moment for every young person, given that the professional life of the worker is often decisively influenced by the first contact with the work environment. One of the priorities of the legislator should be to ensure a legal framework that protects and encourages young people, ensuring them the necessary support to move from the study stage to a practitioner in the field in which the young person wants to work. Nevertheless, the internship was not concretely regulated by the Romanian legislator until 2018 by law number 176 of July 17, 2018 regarding the internship. So, starting with that moment, this activity has acquired its own regulation, which establish the concrete way in which the internships can be carried out. In which concern the concept of internship. The internship program is the specific activity carried out by the intern for a limited period of time within a host organization which aims to in-depth theoretical knowledge, improve practical skills, and or acquire new skills or competencies. The internship program therefore involves a host organization and the intern who carries out theoretical and practical activities for a limited period of time in order to acquire new skills or competencies. So those are the main parts of the internship program. Internship program has regarding to the law a multiple purpose, like developing the professional skills of interns, familiarizing with the requirements of the host organization by performing certain activities, or familiarizing with the specific activity of the host organization, gaining professional experience, and which is the most importantly, ensuring transit from the education to the labor market. In which concern the internship contract, this is a civil contract. We want to emphasize the fact that the internship contract is not a labor contract and is defined by law number 176 by 2018 as a fixed term contract between the intern and the host organization, under which an intern undertakes to prepare himself professionally and to carry out a specific activity for and under the authority of a host organization, which undertakes to provide him with an allowance for internship and all the conditions necessary to achieve the purpose provided by the named law. We will see that there are a lot of similarities between the internship contract and the labor contract, although those are different. Regarding the formal conditions, the law establishes the written form as a mandatory condition ad validitatem, together with the conclusion of the contract in Romanian language. The host organization has some obligation, like sending to the county employment agency or to the municipality of Bucharest the data and information from the internship contract to be entered in the electronic register. In which concern the duration of the contract, it is maximum 6 consecutive months with a maximum of 720 hours without the possibility of extensions. Anyway, as an exception, in the context of Romania held the presidency of the Council of the European Union in 2019, the internship contracts were concluded for a period of 12 months with interns who were involved in organizing the events held on this occasion. So we want to emphasize the fact that internship it's possible both for the private and public sector as well. The intern shall be entitled to an allowance which must be at least 15 of the minimum gross basic salary in the country guaranteed in payment, and shall be granted in proportion to the number of hours worked. So this is a very important part of the regulation, because the internship activity is mandatory paid. The intern is mandatory paid. Another important legal provision of the law is the fact that the intern, the period in which the intern carried out the activity based on the internship contract, is considered seniority in work and, as the case may be, seniority in the specialty, depending on the type of activity. So we see that first the intern is paid, and the second has seniority in work, which are two important provisions of the internship law. The internship contract ends in some situations regulated by the law. For example, at the expiration of the term established in the contract by mutual agreement, when the host organization ceases its activity de jure, and de jure, for example, if one of the party doesn't fulfill its obligations by the contract, the other party can send a notification, and if the party which is not respect their obligation doesn't fulfill the obligation in 5 days, the contract ends de jure. And also, by concluding an individual employment contract between the parties, and it's very important to say that the law encourages the conclusions of individual employment contract, which is a fact that helps the interns to be a part of the labor market. And also the internship contract ends by unilateral denunciations and in other situations provided by the law. The intern's mentor has the obligation to draw up a report on the activity submitted by the intern within 5 working days from the completion of the internship program. The law explains the procedure for evaluating the activity of the intern, and if the internship contract terminates prematurely through no fault of the host organization, the mentor shall prepare the report only for the period of time during which the intern was in the unit, expressly stating the reason why the contract ended prematurely. Anyway, the procedure for evaluating the activity of the intern is very well regulated by the law. As I said before, the law encourages the parties to conclude individual labor contracts. So the host organization, which within 60 days from the completion of the internship program conclude an individual employment contract with the person who carried out the internship program, receive upon request from the unemployment insurance budget an employment promotion premium of the amount of approximately 1,000 euros for each person thus employed after fulfilling the obligation to maintain employment relations for an uninterrupted period of at least 24 months. So this is the way that in which the law encourages the host organization to conclude individual employment contracts with the interns after the finish of the internship program. I want to present you some elements of comparative law in the matter of internship. And the International Labour Organization conducted a study in 2018 on the situations of internship regulation in certain states. According to the analysis above mentioned, the most comprehensive regulations of internship are in Argentina, Brazil, France, and Romania. In Argentina, Brazil, and France, internship activities are carried out on the basis of a tripartite agreement signed between the intern, the host organizations, and the intern's educational institution. Some courts in Australia or the United Kingdom have held that interns can be assimilated to employees, forcing host units to provide them with certain allowances. Australia is the only country where a government institution called the Fair Work Ombudsman, which has imposed sanctions on companies that have violated the rights of interns in internship. In Germany, the legislation governing non-discrimination and combating harassment at work also applies to interns who are involved in internship activities. However, in countries such as China and Japan, the status of intern is unclear, which no precise regulation in this regard. Ensuring for the first time a legal framework for internship is undoubtedly a positive aspect in the Romanian legislative landscape. In synthesis, I want to emphasize some facts about the regulation of internship in Romania. The internship represents the specific activity carried out by the intern for a limited period of time within a host organizations, which aims to deepen theoretical knowledge, improve practical skills, or acquire new skills or competencies. Internship programs can be organized both in the private system and in the budgetary system. The internship is based on a civil contract signed between the intern on the one hand and a host organization in the other hand. The intern carries out his activity under the guidance of an employee of the host organization who has the quality of mentor. During the internship, the intern receives an indemnity and benefits from seniority in work or specialty. The law protects the intern in the sense that he cannot be delegated tasks that exceed his theoretical and practical training, and the host organization cannot conclude internship contracts to avoid concluding employment contract. The state encourages, through active financial measures, the host organization to conclude individual employment contracts after the conclusion of the internship program with interns, which is also the main purpose of internship activity. So, as a conclusions, when the internship is for the first time regulated in Romanian and these circumstances, and we have a de lege ferenda proposal, because it's very important to have a de lege ferenda proposals in every situations is a place for a better reglementation. So at the international level, the International Labour Organization, ILO, although it has not issued conventions or recommendations in the field of internship, makes constant efforts to promote the rights of young people in order to enter the labor market. In this regard, the ILO has launched the Young Employment Program, through which it provides assistance to member states in order to promote and coordinate the employment of young people. The European Union is also making efforts in this regard, mainly by offering internships in the European Union institutions. But considering the importance of the field, we think that international organizations should be more concretely involved in establishing a general legal framework in the field of internship. In this respect, at least one recommendation or even a convention of the International Labour Organization, together with a legislative act from the European Union, such as a directive, would significantly contribute to safeguarding the rights of young people at the beginning of their career. Thank you for your attention, and this is my contact data for any other questions regarding that topic. I wish you a good day, everyone.